Hello everyone. Let us look into the provisions of the Civil Procedure Code section 113, which provides for reference to the High Court. The scope of this provision is that a court under the Civil Procedure Code, whenever there is a civil case before the court, can state a case and refer that for the opinion of the High Court, and the High Court may make an order on that particular case as it thinks fit. The object of this provision is that when there is a non-appealable case before the court and the question of law has not been decided by any other court, there is an absence of a question of law, the court should not commit an error by giving its opinion where it has a reasonable doubt. In Chotubai versus Baikashi, long back in 1941, the Bombay High Court said that the object of this provision is to avoid committing an error which could not be remedied later on. Now, the conditions relating to how these reference can be made. Number 1, let us go to Order 46, Rule 1 of the CPC. The condition is that there should be a pending suit or appeal before the court, and that suit or appeal should not be subject to appeal, or there should be a pending proceeding in execution of such decree. And secondly, a question of law or a usage which has a force of law must have arisen in that course of the suit before the court, or in the course of that appeal, or in that execution proceeding before the court. And thirdly, the court trying the suit or appeal or which is executing the decree must have a reasonable doubt on that question of law. When we say question of law, what are the kinds of question of law which could arise? Here we can divide the questions of law on which this court may entertain a doubt into two classes. First of all, those which relate to the validity of any act, ordinance or regulation which is in question before the court. Secondly, other questions which are there before the court. Now, in the case of the first one, that is when the validity of an act, ordinance or regulation is in question, then the reference is obligatory on the part of the court, of course subject to conditions, and the other questions which may arise, it may or it may not go for reference, it is optional. Now, when we say it is obligatory, how is it obligatory? Here again we can say that it is obligatory if the following conditions are fulfilled. We can look into the conditions. First of all, it is necessary for that court to decide that question in order to dispose of the case which is in front of it, when the parties are before it. And in that case, wherever an act, ordinance or regulation is in question, that subordinate court is of a view that that particular impugned act, ordinance or regulation is ultra vires, and there is no any determination by either the Supreme Court or by the High Court to which this court is subordinate that such an ordinance or act or regulation is ultra vires. When to refer? That is, particularly in this case Raliaram versus Sadram, it stated that the reference can be made on a question of law only when the judge trying the case entertains a reasonable doubt about that question of law. Now, who may apply? Here it is mandatory that only a court can refer a case, not a party or a person. The party may apply to the court, and on the application of the party, the court may refer the case to the High Court, or even the court can refer a case suo motu. What are the duties? What is the duty and power of the referring court? Let us look into the provisions. First of all, the reference can be made only in a suit where it is pending, that is, the appeal or execution proceeding is pending before the court, and such reference will be made only when there is a doubt which arises in the minds of the subordinate court on a question of law, and that question must not be any question, but it should have arisen actually between the litigating parties before the court, and the court must be called upon to adjudicate on that matter. And no reference can be made on any further question or any hypothetical question that such a question may arise later. That is not a duty of the referring court. Then in Rangnath versus Hanumanta in 1984, the Karnataka High Court said that a future arising question cannot be looked into, that thing should be before the court at that time. Once it refers, What is the power and duty of the High Court now? Now, the High Court jurisdiction is merely, in this case, it is consultative. That means, it can deal with the reference, and it is not only confined to the questions which are referred to the subordinate court, but if the High Court thinks that there is a new aspect of law which has arisen, the High Court can consider it. The High Court can answer the question and send back the case to the referring court, so that the referring court will dispose of the case in accordance with the law. That means, the High Court can also refuse to answer the reference, it can also quash the reference, and basically the High Court cannot make any order on merits on that case, nor can it make any suggestions to the subordinate court how to decide the case. Its power is only to give its opinion on that particular matter. Then, how the hearing proceeds, what is the procedure at the hearing? Let us look into it. Order 46 Rule 1 says that the referring court should first draw up a statement of the facts of the case, and whichever question of law has arisen, it should formulate that question of law on which it wants to have the opinion of the High Court, and it should also give its opinion on that. After that, the referring court may either stay the proceedings or it may pass a decree or order. There is an option, because when the court is when the thing is pending before the High Court, then the proceeding may either be stopped there and then, or stayed there and then, or it may pass a decree, but such a decree, when it is passed, it cannot be executed, because it is contingent upon the decision of the High Court on that point referred. It cannot be executed unless the copy of the judgment of the High Court on that reference comes to the subordinate court. Then, if the High Court answers the question, now there may be in favor of the plaintiff in that case, or it may be against the plaintiff also. Rule 2 says that if it answers the question in favor of the plaintiff, the decree will be confirmed. If it is answered against him, the suit will be dismissed. In L.S. Sherlaker versus D.L. Agarwal, this question was detailed looked into, considered by the Bombay High Court, where the court said that this reference should be done only when it is necessary to decide the case. If it is not necessary, then the High Court can take any steps, as in this case it was taken. So, it was that the High Court refused to answer, as it was not necessary in this case. So, the suit will be dismissed, or it will be it will be confirmed in that particular case. Rule 3 says that after hearing the parties, if they desire, if the parties apply to the High Court that they need to be heard, if the parties apply to the High Court that they need to be heard, then after hearing the parties, the High Court shall decide those points which are referred to it, and later it shall transmit a copy of its judgment to the court which has referred, and that court will dispose of the case in accordance with that decision which is given by the High Court. Shall dispose, which means that it is mandatory, it has to dispose according to the High Court. It is not a only recommendatory, it has to be followed. Then, what the High Court can do? Here, Rule 5 speaks about the power of the High Court when the reference is made. When the referring court has not complied with any conditions which has been laid down for the reference, then the High Court has the power to return the case for amendment. It can also quash the reference, or it can also alter the decree which has been passed pending. It can alter, it can cancel, it can set aside any decree or order passed while making the reference, and it can also make any other order as it thinks fit. Now, what are the costs in this case? Rule 4 says that the costs are the consequent costs when the reference is made for the decision of the High Court and for transmitting it back. Whatever are the costs shall be the cost which is stated in the case. Now, after looking at these provisions of reference under CPC, there is a similar provision in CrPC, that is the Criminal Procedure Code, section 390 subclause 1, which can be looked into. There it says that when any court, here it is a criminal court, when it is satisfied that a case is pending before it, it involves a question as to validity of any act, ordinance or regulation. See, this is a similar thing, and it is necessary to determine that question for the disposal of the case. In such case, if the court is of an opinion that such act is invalid or inoperative, this word is put here. Here in CPC it is ultra vires, here it is inoperative, and that has not been declared by any high court to which that court is subordinate or by the Supreme Court, then in such a situation that court shall state a case, setting out its opinion, putting forward its reasons, and refer the same for the decision of the High Court. So, this is the reference under CrPC. There is one more provision which is very important for us to look into, that is the constitutional provision, that is the power of the High Court under Article 228. Now, the reference under the CPC and the power of the High Court under 228, what is the difference between that? Let us look into this. Now, the reference under CPC section 113 and reference under Constitution Article 228. First of all, the subordinate court under section 113 can look into the question of ultra vires. Here under Article 228, it says that transfer of certain cases can be done to the High Court. So, the High Court has the power to transfer the cases which involves a substantial question of law as to interpretation of the Constitution. It does not say ultra vires, it says interpretation of the Constitution. Now, ultra vires may be also a question of interpretation, but it may be interpretation of a law. Here it is an interpretation of a Constitution. And in section 113, it can make reference only when the act, ordinance or regulation is inoperative or invalid. Here under Article 228, the subordinate court cannot even investigate into the validity of the act. It has to make the reference. It has to make the reference. Then the subordinate court can refer the case to the High Court if it has reasonable doubt in according to section 113. Under Article 228, it is a duty of the subordinate court to refer the case as soon as it discovers that this case involves a substantial question of law as to the interpretation of the Constitution. The High Court in section 113, according to 113, the High Court may or may not give its opinion. It has a option. In case of Article 228, the High Court has a duty to withdraw the case from the subordinate court to itself or to any other court, and it has to decide the matter. So, there is no option under Article 228. It follows that this power under the Constitution is conferred a duty upon the High Courts because it is the High Court and the Supreme Court which always are responsible for interpreting the Constitution and the provisions. So, these are the points which we have discussed today. Let us compare it with the appeal which we have already discussed. Now, when we speak about appeal and reference, a right of appeal is conferred on the person who files the suit. Here, reference is the power which is vested in the court, not on the person. In appeal, it can be filed to any superior court which need not be a High Court, but reference always has to be made to the High Court. In appeal, the grounds are wider, but in reference, the grounds are limited only to the question of law which is arising in the minds of the court. Here in appeal, it can be filed after the decree is passed or an appealable order is made, but reference should always be made pending the suit before the court. So, to summarize what we have learned today, the power of reference under the CPC and the other provisions enable the subordinate court to obtain the opinion of the High Court in matters of non-appealable cases first of all, and the object of this is that an error of interpretation should not be committed in a case which could be remedied when the case is pending itself. So, I hope you have learned something from this video. If you have liked it, please share it with anyone you would think would be interested. Please leave your comments and I would be happy to reply to everyone. Do subscribe to get more information on everyday law and legal studies. Thank you.